Mr. Bradbury, welcome to Constituting America's Constitutional Chats. We're going to ask if you'll make a few opening comments on today's topic, the Fourth Amendment, and then we'll go to questions.
Terrific. Kathy, thank you so much. Janine, very privileged to be here. Thank you all. The Fourth Amendment, pretty big topic. Let's talk first about the text of the Fourth Amendment. If you look at the text, it provides two protections for the American people. Number one, it protects against unreasonable searches and seizures by the government of your person, house, papers, and effects. This is the basic core requirement of the Fourth Amendment. That's reasonableness in searches and seizures. Second, the amendment provides requirements for when warrants may be issued, warrants to conduct an arrest or a search. It requires that they be supported with probable cause, like probable cause to think there may be evidence of a crime. And they must be supported by a sworn statement by a government agent that describes the particular place to be searched and the persons or things to be seized. Now, this stems from the colonists' experience with the British government before the establishment of our Constitution, when the British government authorized what was called general warrants. So, for example, customs officials would have a warrant that gave them authority to do general searches into anybody's home they want, looking for anything that might be evidence, for example, of illegal smuggling. And this was a great abuse that the founders of our country wanted to protect against. And so that's why the Fourth Amendment was included in our Constitution, making clear that warrants have to be particular. They have to describe with particularity the place to be searched. They have to be supported with probable cause, etc. So no general warrants allowed under the Fourth Amendment. But notice that the Fourth Amendment on its face doesn't tell us that all searches require warrants. It just says they have to be reasonable. And it doesn't define what is a reasonable or unreasonable search. So these questions are for the courts to decide in particular cases under our system of government. And of course, when it comes to the federal Constitution and the Fourth Amendment, the ultimate court is the Supreme Court of the United States. It is the court that issues authoritative interpretations of what the Fourth Amendment requires, and those interpretations override whatever interpretations Congress may have or the president may have. The court gets the last word. But the court's interpretation, the Supreme Court's interpretation of the Fourth Amendment has changed over time. In the old days, many decades ago, the Supreme Court said that a search for Fourth Amendment purposes requires a physical trespass into your private property. So, for example, in the case of Olmstead versus United States in 1928, the government put a wiretap on a man's phone at the telephone office. The government didn't trespass into his house and put a listening device in the house. They tapped into the phone line at the telephone office. And the Supreme Court said that wasn't a search that required a search warrant because it didn't involve a physical trespass on the man's home. This happened to be somebody who was violating prohibition. He was a bootlegger. That changed in 1967 when the Supreme Court issued a decision called Katz versus the United States, where it totally changed its interpretation of what is a search under the Fourth Amendment. The Katz case involved a man who was engaged in illegal gambling over the telephone, interstate gambling, and the FBI was investigating him, and he was using a public telephone booth to do his wagering. I guess he was a bookie. So he would make phone calls. And the FBI put a listening device on the outside of the phone booth that could hear his voice conversations on the inside. And he challenged that evidence as an unreasonable search and went up to the Supreme Court, and the Supreme Court held for Mr. Katz and suppressed the evidence. And the Supreme Court came up with a new test and said a search is when the government is trying to get access to information or materials over which you have a reasonable expectation of privacy. So if there's a reasonable expectation of privacy over the information or materials the government is trying to get access to, that is a search for Fourth Amendment purposes. And the Supreme Court said that the default rule that we presume is that a search requires a warrant approved by a court consistent with the requirements of the Fourth Amendment. But it's important to understand it's not so simple. There are circumstances where there will be no reasonable expectation of privacy. There may be a dispute. Is this a search or not for Fourth Amendment purposes? And there may not be a reasonable expectation of privacy. And so therefore, there really is no search that requires a warrant or that even implicates the Fourth Amendment. So what's an example where there's no reasonable expectation of privacy? Well, one is the information or the material that you want to try to protect is in plain sight. The police or the investigators can just see it like the public can see it. Then you don't have a reasonable expectation of privacy in it. So if the police, for example, stop you in a routine traffic stop and they're questioning you to look at your license and they can see into the car and they see some drugs or contraband, well, you don't have a reasonable expectation of privacy in that, and so it's not going to be a search. Another exception or another case where there's no reasonable expectation of privacy is where you share your information or materials with a third party. So for example, you've got a business and you get some service from the business. And as part of the service, you communicate with the business or you share your papers, your personal effects, your communications with that business for purposes of the service you're getting. Once you share it with a third party, you may not have a reasonable expectation in the privacy of that material anymore. Think about a letter. Let's say I'm a criminal and I'm involved in a criminal enterprise with, I've got a partner in crime, Mr. Jones, and I write him a letter giving him instructions about how I want him to carry out the crime that we've agreed to do. And I write it in a letter. I keep a copy and I put the copy in a file in my desk. But then I seal the letter up in an envelope, and it's a sealed envelope. I put a stamp on it. I put his address and my return address, and I mail it. Okay. While that letter is in the mail, I may have a reasonable expectation of privacy that nobody's going to read that letter and find out. But I don't have a reasonable expectation of privacy in the address on the outside of the envelope because the post office, somebody at the post office needs to read that. And I know that people are going to use that to deliver the letter. And then once the letter is delivered and Mr. Jones opens it up, I don't have control over the information in that letter anymore. We might have an agreement, we're going to keep it secret, but I don't control him. And he might share it with the FBI. He might decide to turn me in, or he might be an agent for the FBI. I don't have control over it. I do have control over the copy in my desk, and that might require a warrant to come into my house to get that copy. But the copy that Mr. Jones has, he controls it. I don't. I don't have a reasonable expectation of privacy in that copy. Another example is transactional information, like phone numbers I dial, or email addresses I send emails to, or websites I search on the internet. That's information I'm sending out to a service provider. They control that transactional information. I don't. They need it for their business purposes. I don't have a reasonable expectation of privacy in that. In addition, there could be things where I do have a reasonable expectation of privacy, and it is a search if the government tries to get access to it, but a warrant is not required under the Fourth Amendment for the government to access it. The most common example is where I give consent to the government. So, for example, if the police stop me for a routine traffic violation, they don't have the right to look in the trunk of my car. I have a reasonable expectation of privacy in what's in the trunk. But they can ask me if I could give permission would I consent to let them look in the trunk? And let's say the police have reason to think somebody's got illegal weapons that they are transporting on the highway, and they're stopping cars and they're asking me, do you have any illegal weapons in your trunk? And I say, no, sir. And they say, do you mind if we look in the trunk? And I say, go right ahead. I've given consent. If they open my trunk and they search for the weapons, there are no weapons in there. But what if they find some drugs? Well, I could be prosecuted. They can use that evidence against me in a prosecution because I gave them consent to look in the trunk. Another example of where warrants are not required is business records. So we have businesses in this country, and they may include nonprofit corporations or commercial businesses, and they're regulated by the government. They have to comply with the law. They have to do honest business practices. They can't violate the antitrust laws or the securities laws or the banking laws. And all those agencies that regulate those companies, those commercial actors, they have authority to look at the records of those businesses. And they may do that by a subpoena. And a subpoena is a way the government can get access to records that does not require court approval. And all it requires is that the records are relevant to some authorized investigation that the government is conducting. In the criminal arena, criminal grand juries have authority to issue subpoenas in their own name to get access to records like that, and they don't require the involvement of a court. So the record may relate to me. It may be a record about my communications, my activities, but because the government can get the record as a business record from the company, or a grand jury can get it based on simply a need that's relevant to an authorized investigation, it's not something that requires a warrant. And another example of something that doesn't require a warrant is when there are exigent circumstances. The police are chasing a robber who's just left the scene of the robbery. He runs into his home. The police can follow him into the home, even though there is no warrant, because it's emergency exigent circumstances. And then the final category is where there's a national security reason. The president protects the country from foreign threats, and where there's national security concern, it's long been established that the president can conduct surveillance, for example, without a warrant for national security reasons. So even though the Fourth Amendment may not require a warrant or may not protect particular information from government access, the last point I want to make is that Congress can provide enhanced protections in statute, in law, that go beyond what the Fourth Amendment guarantees. And I think as we get into some of the discussion topics that have been highlighted, Kathy, in your setup for this program, including communications that may be recorded by smart devices in your home, or the Foreign Intelligence Surveillance Act surveillance, like Section 702, which is up for reauthorization this year. Those are examples of areas that may be addressed by Congress, by law, by statute, where Congress has gone beyond the Fourth Amendment protections to provide enhanced protection. I'd be happy to get into some of those details as we dive into the details of those scenarios. Thank you.
Well, thank you. That was a great overview. And I know Janine has got some questions, and so I'm going to go ahead and hand it over to Janine.
Yay, I'm just glad on my mother's computer I could figure out how to hit the unmute button. So I'm real excited about that. Yes, thank you, Mr. Bradbury. That was really very, very thorough, and I wrote down a bunch of questions. I think my first intrigue is in regard to the branches of government and the Fourth Amendment. I found this to be very intriguing. I mean, I have a zillion questions about other things too, but I would like to focus on this in regard to the Constitution. You said that the Supreme Court has the final say on the Fourth Amendment. But then what was interesting is at the very end, you said Congress can pass statutes that dictate the Fourth Amendment. And I think that's kind of, unless I misunderstood what you said, but I think that's interesting because a lot of times people think the Supreme Court is the be all and end all. And yet Congress can come in and sometimes, if they have enough votes and whatnot, can overrule some things the Supreme Court says. So it doesn't really always end with the Supreme Court. But maybe I misunderstood you, but I thought that was interesting when that last part when you said statutes can be passed regarding the Fourth Amendment. I thought maybe a little clarity there would be fascinating.
Absolutely right. No, it actually is not the case that Congress can reinterpret the Fourth Amendment. Congress cannot, by statute, expand the requirements of the Fourth Amendment. The Fourth Amendment is a freestanding check or limit on the extent of Congress's power or the federal government's power. But Congress has important authority, for example, to regulate interstate commerce. And under that authority, Congress has enacted by law enhanced protections that apply, for example, to communications that involve the internet or telephone systems, because the internet and telephone system are instruments of interstate commerce. So Congress can regulate how they are used and what limitations apply, and they've done that. So, for example, Congress has passed the Electronic Communications Privacy Act, which requires warrants or subpoenas, administrative subpoenas in certain cases, to get access to your electronic communications like your email and your telephone calls. Also, Congress has passed what's called the Stored Communications Act, which provides the procedures and requirements for the government to get access to information that is stored on servers. And this would relate, for example, to those devices in your home, like the Alexa Echo that Amazon makes, or the Google Assistant, or Siri from Apple, what have you. Those services are called remote computing services. You may think you're talking to a little device in your house, but actually the instructions or questions you give it are communicated over the internet to computers that are operated by Amazon. And Amazon has records of what you asked for and what they did in response to your request. They need that for their business, for example, to ensure they're providing good service to you. The government may want access to those records. For example, it may be relevant to a criminal investigation. Something happened in your home, and they want to know if there's evidence that your Echo device picked up that Amazon has on its servers. They can go to Amazon to get that. They don't need to come to you to get it. And the Stored Communications Act, in the Stored Communications Act, Congress has specified when they can get access to it, under what circumstances. The Fourth Amendment might not provide any protection under the Constitution, because this is a record you have voluntarily allowed a third-party business to have for your own. You want to have that device in your home, and that communication goes over to Amazon servers. They have that information. You don't control it anymore. The government doesn't need a warrant to get it under the Fourth Amendment.
Does the same thing apply to Siri? Like Siri's always listening, but could it take a conversation that you're having in your house before you've asked Siri a question? Or does it have to be a direct question to Siri? Because, Siri's always sort of listening. That's why suddenly, if you talk about house shoes, there are 1,000 house shoe ads on your Yahoo,
Right.
But when does that become evidence of someone seeking it? Because Siri's always sort of listening. Does it have to be a direct ask to Siri?
Well, anything that the company may get as part of the service they're providing could be fair game to government investigators. But these companies obviously have an interest in letting you be comfortable that your privacy is respected. And so they put limits on when these devices currently will record what you're saying and send it to the company's servers. So for example, with Alexa, you have to give a wake word, like the wake word could be Alexa or Echo or Amazon. And with Google, you have to say, hey, Google, or something like that. And then it will transmit whatever is said after that to the servers. And there have been cases where, for example, suspected crimes have occurred in a home. There's a body. The government thinks the person was murdered, and they think there may be evidence that the Echo device has collected. It's just possible. They don't know for sure, but they want to check it out. So the grand jury may issue a subpoena to Amazon to get a copy of any recordings from that evening in your home. And you know,
yeah. Then that's without the ask. That's without asking, hey Siri. It's just any conversation it might have picked up, Siri might have picked up.
Well, I believe that currently these companies limit the actual recording to when the wake word, when they hear the wake. They have to have microphones that are listening all the time in order to hear the wake word. What they say is those microphones don't record. They're not collecting information, and that's just staying in the device. But once they hear the wake word, then they start recording what you're saying, and they send it by the internet in a data file to the company. Because the company has to do something in response to your question or your instruction.
I only have a certain amount of time, so I want to kind of ask a quick question and then kind of surmise something. You know, it's really interesting what you said, because I always believe, you know, the First Amendment is not negotiable. You know, it's an amendment that the Supreme Court can interpret, but you can't vote that away. Someone can't, you know, mass anarchy or populists can't say, oh, you know, because they're inalienable. We're born with these rights, so to speak. And I kind of feel that way about all the Bill of Rights. So I'm really glad that Congress really can't override what's in the, you know, the Bill of Rights. Except it's so interesting that there is, you know, subtle ways that they can with the interstate commerce. So I just wanted to say that I do believe that especially the First Amendment is inalienable. So you can't really vote that away, or Congress can't take that away, because that'd be really dangerous if suddenly in our Bill of Rights, or especially the First Amendment, if Congress could, you know, say, you know what, you really don't get that right to free speech.
Right.
That would be dangerous. Okay, so my last question to you is, but it's really interesting how through interstate commerce they can manipulate that. I'm really curious in my last question here about the phone booth, because, you know, I'm thinking about all the pictures that are taken on the streets now of us in every corner and every parking lot, and, you know, there are cameras everywhere. But the phone booth is a public phone booth. So it's really interesting to me that they felt that could be that the defendant won in that it was his private conversation.
He had expectation of privacy when he closed the door to the phone booth. But Janine, you're dating yourself. I think probably a lot of your young listeners or watchers may not even know what a phone booth is.
Oh, think of London, the little red booth. Yeah, phone booths. I miss them. Okay, so the privacy was when he closed the door, even though, because I guess we don't have any equivalent of that now with all these cameras on the street, so to speak.
We're definitely losing the sphere of reasonable expectation of privacy. It can change based on circumstances. And if everybody starts getting these connected devices, these Internet of Things in your home, and you're talking to them and you're using AI now, you know, the AI is based on servers. It operates on servers that companies offer someplace else, you know, goes out over the internet, and it's always listening. You're always talking to it. It's going to be doing things for us. There's going to be a much reduced sphere of reasonable expectation of privacy. And I think the Supreme Court will have to grapple with that going forward as it interprets the application of the Fourth Amendment.
Really interesting. Okay, I'm going to pass to Tova now. I didn't get a time card, but I feel instinctively my time I need to pass. So I'm passing. I can ask questions all day. I have a whole list here, but I'm going to pass to Tova here. There you go.
I do
Tova.
want to talk about Section 702 at some point. But
yeah, please do. Section 702. Yes.
Yeah, thanks, Janine. So, just as a follow-up question, I was wondering if you could talk a bit about the attitude of corporations towards, like of specifically technology corporations towards government warrants, because I know in the news, there's been some stories about companies like Apple being very resistant to complying with, government attempts to get access to locked phones. So I was curious, we've talked about the sort of user side and the government side, but could you talk about how technology companies have treated these requests by the government historically, and what you see heading to the future as the sphere of privacy becomes smaller and therefore these companies have more power?
Right. So the companies are very keen to assure their users that they protect your privacy. And so they want to be in a position to tell you as a user that we're not going to turn over your information that we have on our systems to the government unless we have to. But the question is, under what circumstances will they have to? And in the fine print of their contracts with the users, they have to say, and they do say, that we comply with all lawful orders for information. So if they have records that they control and have access to, and the government has a lawful order requiring them to turn it over, it may be a warrant approved by a court, or it may be a subpoena, they will typically comply with that. Now, if the subpoena is very broad and unreasonable and burdensome, they could go to court and say it's too burdensome or it's not really relevant to an authorized investigation, but the courts are pretty deferential when there's a government agency that has authority to get it or a grand jury that needs it for an investigation. So Apple, with its locked phones, that was sort of a new approach. They said, okay, we're going to give you, Tova, the ability to control access to what's on your device. We don't have it ourselves. It's on your device. And you decide what the code is, and we don't even know what it is. Query whether it's really true that Apple doesn't know what the code is. I'm not sure that's a reasonable assumption. But there are, I think, programs that allow the government to get into that phone. The government just needs to get, control of the phone, and they can get that with a warrant from you, for example. So I think companies have an interest in improving the privacy, making you feel more comfortable that your privacy is protected, giving you the ability to use encryption and other things. And that will keep evolving, keep improving. And then the government and its investigators will also keep improving their techniques, and it will be a balance and a trade-off that will continue over time. It's an old story in new form.
Yeah, that's really interesting. And I can imagine, companies have to sort of signal strongly about, consumer data being protected, because otherwise, if there's kind of a free market and people can move to other devices or other companies, it could kind of lead an incentive for companies to like signal that they're protecting your data, even maybe more than they would otherwise want to, based on the executive's beliefs. So that's really interesting. And then I was curious, you were talking earlier about the idea of similar to other amendments, the rights of the Fourth Amendment being able to be suspended in a emergency or in the name of, national security. But I mean, this is an age-old question, but how is that determined? And then what sort of protections are there to make sure that somebody couldn't come into office, or some head of an executive agency couldn't stretch those powers, claim it to be a time of national emergency or a national security risk, to violate it, these amendments?
Well, we have a long history on this. Remember, I said that under the national security exception to the warrant requirement in the Fourth Amendment, doesn't mean the Fourth Amendment doesn't apply. It's just a question of how does it apply in the national security context. Although the Supreme Court itself has never ruled this way, hasn't addressed the question, the courts of appeals have consistently held that the president has inherent authority under the Constitution to conduct warrantless surveillance for national security purposes. to protect the country against foreign threats, whether they be terrorists, foreign nations, spies from foreign nations, etc., and doesn't require a warrant to do that. However, as you probably know, there were great abuses of that authority in the 1960s and early 70s when the Kennedy administration, Johnson administration, Nixon administration conducted warrantless surveillance really focused on domestic concerns. These were really not foreign powers at issue, but domestic concerns. And in the Kennedy administration, the FBI was doing warrantless surveillance of Martin Luther King and other civil rights leaders. These were abuses, and they were investigated by Congress in the 70s. You may have heard of the Church and Pike committees, and they exposed these abuses of foreign intelligence powers. And that resulted in another statute enacted by Congress in 1978 called the Foreign Intelligence Surveillance Act. And that's an example, another example of Congress by statute creating enhanced procedures to provide protections against incursions into Americans' privacy interest. That's an example of a statute that was a compromise, a balance between the president and Congress to create a system that would allow federal courts to be involved in approving orders to do foreign intelligence surveillance. And it's something that basically the president has acquiesced in that as an accommodation to secure the whole system, make it more sustainable and consistent with the expectations Americans have not to be under surveillance like that. And now there have been abuses of that. Section 702 is part of FISA. It was enacted in 2008, and it allows the executive branch to do pretty broad scale surveillance, not individualized one-by-one orders, but a very broad scale program of surveillance that's targeted at foreigners, not US citizens or residents of America, but foreigners who are believed to be located outside the US. It targets them, and then it collects their communications that may flow over facilities in the US, like internet facilities in the US, but it's targeted at foreigners outside the US. Collects a lot of very valuable intelligence information on terrorists, on the Chinese government and what it may be trying to do in the US and around the world, etc. It doesn't require a warrant because it's not focused on any person in the US and any reasonable expectation of privacy in the US targeted at foreigners. However, it collects a lot of communications with Americans. The other end of many of those communications will be in the US and they may involve Americans. And it collects a lot of that communications in a huge database. And there have been real issues with the FBI's use of that database for improper reasons having nothing to do with national security. Over 278,000 times, according to the FISA court, the FBI has tapped into that database to gather information on Americans with no national security purpose. That's very improper. That whole authority, 702, is up for reauthorization at the end of this year. It's very controversial for the reasons I described, and Congress is considering whether to keep it the same or revise it, amend it, and reauthorize it, or let it expire. In light of the attacks in Israel and the issues we currently face with the existing or threat of terrorist activity, I have a feeling there will be a strong push to reauthorize it, but there may be limits put on how and when the FBI can access that data.
That's really, really interesting. Thank you for that overview. And if a lot of this intelligence collecting is by nature classified or part of a government investigation that the general public can't know about, how does the US public, how are we able to, hold the government accountable if we feel that they're violating the 14th Amendment or even know of this, or even from the perspective of Congress?
Well, you're absolutely right. Well, three ways. One is the court and the government has to provide information to committees in Congress that do oversight of the program. Second, the court and the government, the Justice Department, will from time to time, and the Director of National Intelligence will from time to time declassify information about the program and publish that, make it available to the public. And then number three, in individual cases that raise real sensitive issues, the court can appoint, under recent amendments that have been made in recent years to FISA, the court can appoint an amicus who has clearance to get access to classified information, but whose job is to write a brief and advise the court on the protection of privacy interests and whether a particular request for surveillance is going too far. So the court will get to hear from an amicus, an independent amicus. The court, by the way, is not some special star chamber court. It is a federal judge, a district court judge who has life tenure, and a regular Article III judge who gets assigned to sit on the FISA court for a period of years. And so we do have the protection that's provided by an independent judge as well.
I see. Thank you so much for that, very thorough overview. I appreciate you being on, and I'll now pass to Jorn.
Thanks. Hey, Jorn.
Hello. I have a question that I actually witnessed personally. I'm not sure if it is connected exactly to the Fourth Amendment because it is not by government, but I just wanted to pick your brain about it a little bit. If I am having somebody in my home, okay, and I have recording devices, why can I not use those recordings in court?
Yeah. Well, under the federal law and under the law of most states, you can, because you are a party to the communications. Your home, you are a party to the communications. And when you decide to record it, you're giving your consent to recording that conversation, even though you haven't told the other person, the other party to the communication. And under federal law and the law of most states, all that is required is the consent of one party to the communication to record it. However, Jorn, not sure where you live, but the laws of 11 states, including some big states like California, Florida, Illinois, Massachusetts, Maryland, Connecticut, several others, does not include New York, does not include DC, does not include Virginia. I'm not sure where you are, but the laws of 11 states require what's called two-party consent. So they would require you to get the consent of the other party to the communication before you could record it. And so if you did what you described in those states, you're actually violating state law. You could be prosecuted for that. And
Okay.
it goes without saying you couldn't use it in court against.
Gotcha.
But in most states and under federal law, you could. And so that's why you see, private investigators sometimes, people will use private investigators to record communications, or you could wear a wire, as they say on TV.
And that's the single party, right?
Single party, yeah.
Yep.
Right.
Okay. That clears a lot of things up. As far as Section 702 goes, what are your personal thoughts on what should be done? Do you just think it should be altered? Do you think it should kind of just draft a new version of it? What do you think? Like, what do you think would be best for us?
Well, I actually have written on this as part of a report I did for the Heritage Foundation, because this is a big issue that Congress is facing this year. It expires, as I mentioned, the end of this calendar year, unless it's extended. In the past, it has been extended. It could be extended for a period of time while they continue to consider it. There's always a reluctance on the part of members of Congress to just let something expire if the government is telling them, the executive branch is telling them there's a critical national security need to keep this program in place. And this 702 program that I mentioned is very broad. We have close to 300,000 targets under surveillance in this program. They're all located outside the US. A lot of it could be China, a lot of it could be suspected terrorists, etc. And it provides, this program alone provides more than 50% of the information that's in the president's daily security briefing. So this is some of the most valuable information for national security protection reasons that we collect. However, it's extremely broad. And what's really disturbing is all these unauthorized uses of the database by the FBI. They can't seem to control themselves. And so one of the recommendations we've made is that Congress, in reauthorizing it, should insulate the FBI from the 702 program and not allow the FBI to have direct access to the database under its own control, and rather limit that access to national security agencies. And if they see something that the FBI needs to know about, because some suspicious activity is happening in the US, they could tip that information to the FBI in a security report. And the FBI doesn't have to have access directly to the database. Now that's controversial, and the FBI will kick and scream about that. But our view is that the 702 program is not primarily an FBI program. It's primarily focused on those overseas threats and doesn't require immediate involvement of the FBI. It's complicated questions, and people who have security clearances, members of Congress, they'll have to make that hard judgment.
Yeah. But thank you for your 2 cents. It was valuable to me. A little bit about searches. Now, obviously, you must give, if a cop comes to your door to search your house and you say, okay, as you said, whatever they find is obviously usable. What are the rules on making you feel like you can be criminalized for not letting them in, or coming in the middle of the night?
Yeah.
How is that handled?
They really should have a warrant, Jordan, and you have no obligation to allow them to come in and to give them your consent to search the home under most circumstances. Again, remember, if there's an emergency happening, exigent circumstances, there will be exceptions. But for the most part, you have the ability to say, no, I need you to get a warrant. They can get a warrant, and it's not that hard to get a warrant. The judges are assigned to be on call 24 hours a day. There'll be a judge at the court. They can call them up. They can do it over the phone. Okay. And they can provide the information that's needed. What the judge will look for is there probable cause to believe they will find evidence of a potential crime in your home. For an ordinary criminal matter, that's the standard. But judges make those decisions all the time, and they often will trust the police. The police or the FBI will sign a quick statement that's a sworn statement. And if the judge says it looks like ones I've approved before, boom, it can be pretty quick. They will get it, and then be, emailed to them, and they can come to, and there it is. They're obliged to give it to you, show it to you. You're entitled to get a copy of the warrant, and then you have to let them into the house. Or even if you don't let them, they will let themselves in.
This had happened to my friend, and it was nothing to do with him, but he was made to feel like, if I don't let the cops in my house, then I can be arrested. But so I was just a little bit, they didn't have a warrant, they didn't have anything. Just kind of the forcefulness of it.
It's natural. It's human nature. You want to be cooperative. You don't want to look like you have something to hide. You want to respect authority. So all of us will have an inclination to say, sure, you can come in, look in my trunk or what have you.
Well, it's time that we jump to some audience questions, but thank you very much for the time I had with you, and I'll pass it to Kathy.
Well, thank you, Jorn and Tova and Janine, for your great questions. And we are going to get to some audience questions in just a minute. First, we want to recognize our students and teachers that are watching today. We have Gail Peck with some homeschool students watching, Alan Amdahl with 25 Albany senior high school students watching, D'Angela Hines with some homeschool students watching. And actually, she's from Emerald Coast Christian Academy, D'Angela Hines at Emerald Coast Christian Academy. So thank you to all our students and teachers. If you're a student or teacher watching and we didn't give you a shout out, type your name in the Q&A and we'll try to get to you before the program ends. We also want to thank our listeners listening to Las Vegas's KKVV 1060 AM on the radio dial. KKVV airs these constitutional chats Mondays at 6 p.m. Pacific. So thank you to all the KKVV listeners. So Mr. Bradbury, Robert McKeeman asks, does this amendment apply only to citizens, or does it apply to people who might be here in our country either legally but not citizens yet, or people who are here illegally?
It applies to all persons in the United States. It's a guarantee, as the text of the Fourth Amendment says, the right of the people to be secure in their persons, houses, places, and effects against unreasonable searches and seizures shall not be violated. So it applies to all people in the U.S.
Thank you. And then Jill asks, how did the Patriot Act change our Fourth Amendment rights as U.S. citizens?
Well, number one, let me emphasize that no statute that Congress passes can change your Fourth Amendment rights. Those are constitutional rights. Congress can't take them away by statute. Congress, as I was attempting to explain earlier, can provide additional protections beyond what the Fourth Amendment provides by statute. And what the Patriot Act does is, frankly, is exactly that. The Patriot Act applied law enforcement type tools to some national security related investigations in the wake of 9/11. And it provided greater flexibility in certain cases for national security investigations than they previously had, based on models that are already used in ordinary law enforcement, or, for example, in connection with investigations of organized crime. So Congress determined after 9/11 that it didn't make sense anymore for national security investigations to require more onerous procedures and more restrictions than investigations of organized crime. We wanted to start treating them similarly. And so that was part of what the Patriot Act did. It made a series of reforms, most of which have now become permanent, to change the procedures required under some of these authorities, these statutory authorities, for investigators to get information relating to national security, to make it look more like other types of law enforcement investigations.
Well, thank you.
That's my explanation. Critics of the Patriot Act, just in full disclosure, may have a different way of describing what the Patriot Act did. And, you know, there's a lot of sort of sinister descriptions of what the Patriot Act did, which I don't really think are accurate, but it's a much more complicated subject. We could spend a whole nother program on the Patriot Act.
Well, thank you. And then Andrew K asks, what, if any, recourse does a private citizen have when, as we've seen in the past several years, one or more of the restrictive protections within the Fourth Amendment are violated?
Yeah.
And how and by whom are such recourse actions affected?
Well, there are a couple of different things you can do. Number one, if the government tries to take action against you, like a prosecution, a criminal prosecution, and they're trying to use evidence that you believe was secured by the government or obtained through a violation of the Fourth Amendment, an unreasonable search or seizure, you can challenge the use of that evidence. And the court, if they find that it's a judge who, not a jury, a judge makes this determination that you're right, your Fourth Amendment rights were violated, the judge will, you've probably heard this phrase, suppress that evidence. It's considered the fruit of the poisonous tree. In other words, the search was unlawful. Therefore, all the evidence that was obtained was unlawfully obtained, and the court will tell the government you can't use it. It's excluded from the prosecution. They can't rely on that evidence. That's the number one remedy you can get. In some cases, the Fourth Amendment is sort of a unique protection under our Constitution. It's the one protection that the Supreme Court has said you as an individual have the right to bring your own action in court. It's called a Bivens action against the government agent who violated your Fourth Amendment rights to seek money damages for that violation. That's the Fourth Amendment is the only provision of the Constitution where the court has recognized that right, and they've limited it to very narrow circumstances. So it's not a very broad right, but it is there. It does exist, and that's another form of relief that's available.
Very interesting. And then finally, I think this is a great summary question for this episode. Jill Marie Smith asks, can you share your opinion of what Ben Franklin said, that those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety?
Yes. Well, we often talk about the balance between individual liberty and national security. I don't really think it's a balance as much as it is an understanding of how these rights interrelate. And I think one thing I would hope you take away from this overview of the Fourth Amendment is that it's based on a question of reasonableness under the circumstances. And if you think about it, it's not like, as Janine was describing, the First Amendment, which is more of an absolute protection. Congress shall make no law infringing your right of free speech. That's pretty clear. But the Fourth Amendment, it's there shall be no unreasonable searches. Well, what's reasonable? It's kind of in the eyes of the beholder. It's up to the courts to decide in individual cases. And sometimes that does require something of a balancing. But it's not accurate to say that the Fourth Amendment goes away or doesn't apply when we're talking about national security. It just applies a little bit differently. And in particular, the warrant requirement is relaxed or perhaps doesn't apply. But all searches have to be reasonable under the circumstances.
Well, thank you. This has just been a fascinating episode, and we're right near the top of the hour. And I just want to go back and to Janine and Tova and Jorn and see if you'll have any closing comments or questions real quick.
I just want to say thank you. Great job, Mr. Bradbury. We could go on forever and ask questions forever.
I'd be happy to for future.
So you think the First Amendment it's unalienable, but Second, Third, Fourth, Fifth, Seventh, all the way through 10?
They're all unalienable. They're all unalienable. It's just a question of what do they mean? How do they apply? And Fourth Amendment is pretty complicated, as I've described.
So they're all unalienable, but some have a little more of a window. Like
wiggle room, I guess. Wiggle room.
Wiggle room. Okay. Yeah. Well, that's great to know. Thank you. Thanks so much.
Thank you so much for being on and sharing your expertise. I learned a lot.
Great. Happy to be here.
Yeah, thank you. And thanks for a great show. I appreciate you. Hopefully you're back.
And thank you to our audience, and come back next week on Tuesday, October 31st. We're going to be talking about the Fifth Amendment. So we'll see you then. Thank you.